Gledhill.
My lady, I'm going to take it ground by ground, if I may, starting with ground 1, Roman 1, which is construction of the settlement agreement. BCCI tells you that no special principles apply to the construction of settlement agreements, and that one does not approach them with any particular legal presumption as regards whether they settle particular kinds of claims, even fraud claims or dishonesty claims. See BCCI, see the Marsden case, see the Elite case. There's no need to go to them. They are in the bundle. The exercise, therefore, is the familiar one of reading the words in the context of the whole of the agreement and in the factual context and deciding what the words objectively mean. BCCI is obviously the key case. The judge quoted it at length from paragraphs 87 to 90. You'll be relieved to know that I'm not going back there. The principles are that there are no special principles. That then takes you back to conventional principles of contractual construction on orthodox modern principles. See Rain and Sky, see Arnold and Britain, see Wood and Capita. The principles have been distilled in numerous judgments. One example is the ABC case, which the judge cited at paragraph 86 of the judgment, which is page core bundle, tab 11, page 225. Just pick this up on the page before, page 224. You can see that the judge below is citing the judgment of Lady Justice Carr in ABC, and Mr. Fenwick sort of skim-read this to you, and he also skim-read the first Roman 1 over the page. I would like briefly, and this will be the only bit of authority I go to on construction, to show you Romans 2 and 3 on page 225, please. So Roman 2, Lady Justice Carr says, the reliance placed in some cases on commercial common sense and surrounding circumstances should not be invoked to undervalue the importance of the language of the provision which is to be construed. The exercise of interpreting a provision involves identifying what the parties meant through the eyes of a reasonable reader and, save perhaps in a very unusual case, that meaning is most obviously to be gleaned from the language of the provision. Unlike commercial common sense and the surrounding circumstances, the parties have control over the language they use in a contract. And again, save perhaps in a very unusual case, parties must have been specifically focusing on the issue covered by the provision when agreeing the wording of that provision. When it comes to considering the centrally relevant words to be interpreted, the clearer the natural meaning, the more difficult it is to justify departing from it. The less clear they are, or to put it another way, the worse their drafting, the more ready the court can properly be to depart from their natural meaning. However, that does not justify the court embarking on an exercise of searching for, let alone constructing, drafting infelicities in order to facilitate the departure from the natural meaning. And I will skip over, if I may, because this is obviously fairly trite stuff, to page 226, again from the same judgment being quoted by the judge below, the middle of this paragraph, so quoted paragraph 19, about 7 lines down, she says, this is not a literalist exercise. The court must consider the contract as a whole, and depending on the nature, formality, and quality of the drafting of the contract, give more or less weight to elements of the wider context in reaching its views to that objective meaning. The interpretive exercise is a unitary one involving an iterative process, etc. Well, so far, so trite, but the point of reading this passage is that in this case, we have a settlement agreement that is professionally drafted and has a clear natural meaning, and indeed a clear and agreed natural meaning. And the clearer the natural meaning, the less justification there is from departing from the natural meaning. MRL criticises the judge for over-literalism and for not paying enough attention to the context. And there's just nothing in that criticism, I'm afraid. It's the kind of criticism that, you know, one could conventionally make, but as a matter of fact, there's nothing in it as applied to the facts of this case. He clearly had the correct contextual approach well in mind, and he paid full attention to the factual context, indeed, much more of the factual context than MRL pays any attention to. And the judge found, as a first step, that the words of the release were clear as regards their natural meaning, and that there was nothing in the context to displace their natural meaning or to confine the natural meaning somehow. And then he turned to the context and found that the context strongly supported the natural meaning. So with that in mind, could we please go to the settlement agreement? It's in the supplemental bundle, tab 16. And obviously, you've seen the settlement agreement before, and bits of it were read to you. So I'll take it as quickly as I can. But I suppose my point is, it's important to see first just how clear and comprehensive the drafting really is, including of clause 3.1, the release, which you weren't shown. And secondly, actually, how much factual context is referred to in the recitals. There's the obvious point that Mr. Fenwick made, that on page 1 we can see that Lohomij is a party. We see that on page, I should say page 136, tab 16, 136. That's repeated at 138, Lohomij is a party. Now, the letter before action that we'll come to made no express claims against Lohomij, but on any view, this settlement agreement settles claims against Lohomij. So that alone tells you that the letter before action can't be read as somehow confining the claim, and there are other reasons for that as well. There are recitals at page 138A over the page to F that I'll come back to in a moment. The release is at page 141, clause 3.1. It's headed full and final settlement and release. You have to ignore that bold heading because of the conventional clause that says you ignore headings, but it is in fact apt. 3.1, the parties agree for themselves and on behalf of each of their affiliates and agents that this agreement shall constitute full and final settlement and irrevocable and unconditional waiver and release of all and any claims. Well, I make the very obvious point that the language is apparently unambiguous and comprehensive, and whatever claims with a capital C are, the intention is clearly that those things be settled, and the settlement clearly covers affiliates and agents of all parties. And the judge said rightly at paragraph 111 that the impression that was created is that the parties wished to cover all bases in drawing a line under their past dealings concerning the collection, and I suggest that that's plainly correct. Clause 3.2 essentially covers off some of the sneaky ways that a claim might anyway be brought, and you can see A to D. I won't read them out, but if one does read them, you can see that in Lord Hoffman's terms, this drafts person meant business. Clause 3.3 specifically reserves the Bonhams and Lohomij claims, and those of any of their affiliates and agents. And, for example, that's quite understandable where Lohomij had rights under the facility agreement. But there is no other carve-out, if I can put it that way, in relation to whatever MRL is giving up. The carve-out is for Lohomij and Bonhams. Claims is defined at 139, and I won't read it out because it's been read, but the first 5 lines, again, on any view, are pretty comprehensive. It's all claims, causes of actions, rights, or other interests, whether present, actual, prospective, contingent, whether or not known, etc. It's very wide language. There are no exceptions except for the express ones in the last 3 lines, excluding, for the avoidance of doubt, the Bonhams and the Lohomij claims. Those are their affiliates. There are limiting words that start at about line 5. So that it's all claims, etc., which relate to, arise from, or are otherwise connected with. So, and then there's a list of events. And those events are the initial acquisition, one could put square brackets around that, it's financing, the sale of the collection, and the 30 June agreement, which is also known in the proceedings as the commercial agreement, it's the same thing, and including all claims alleged in Spring Law's letter, which I'll call the letter before action. So the claims are limited to claims that relate to this subject matter, but in fact relate to isn't quite right, because it's relate to, arise from, or are otherwise connected with. And essentially, these are all the events between the parties from late May 2014 to the auction in mid-August 2014, but the cut-off date actually runs forward to the date of the settlement agreement, which is the end of July 2015. And the release is framed mainly by reference to the definition of claims, which is used in the release, is framed mainly by reference to factual subject matter. So it's these facts of the initial acquisition, the financing, the sale, the commercial agreement. Some causes of action are touched on, but there is no attempt to mention every possible cause of action. In line 3, you can see at a high level, whether arising in contract or under statute or otherwise, does not purport to be comprehensive, because the way it works is that all claims arising from or connected with this bundle of facts up to the date of this agreement are settled. The claims include those alleged in the letter before action. We've got that word including 5 lines at the bottom, 5 lines from the bottom of the definition. Including, and words like including, are defined at 1.2J over the page 140. So J says, a reference to includes or including will be construed as includes without limitation or including without limitation. And in fact, K says general words should not be given a restrictive meaning by reason of their being preceded or follows by words indicating a particular class. So there's no question of, turning back to claims, that the list of events somehow being qualified or limited by the content of the letter before action. And the judge said about this at paragraph 112 of the judgment, the parties are seeking to draw a line under events up to the date of the settlement agreement. And that's just plainly right. He read the words in clause 3.1, together with the definition of claims, together with the recitals, and he compared those words, the claims being made in the amended, or the draft amended particulars of claim, and he decided that claims predating 31 July 2015 clearly, in his words, fell within the release according to its natural meaning. That was his finding at paragraph 114. Now, obviously, considering the word's natural meaning was not the end of the exercise, but it was an acceptable and indeed perfectly correct starting point. And MRL, and this is an important point, MRL doesn't actually challenge that natural meaning. And nor could it, realistically. But what it says is the judge somehow was over-literal or shouldn't have stopped there. And that takes the judge and takes me to the factual context. And most of the relevant factual context is referred to in the recitals, actually, which start at page 138. So at recital A, this refers to the 29 May facility agreement. This is between MRL and Lohomij, and importantly, not with bonds, for the acquisition of the collection. B refers to the 30 June agreement or the commercial agreement, signed 30 June, stated to be effective as at the same date as the facility agreement. This one is a three-way or tripartite agreement between MRL, Bonhams and Lohomij about the sale of the collection, including the 10 cars in California Quail Lodge. C refers to B&B's conduct of the auction, 14 August 2014, and of other sales. And D and E are the most important ones. D says, MRL has made numerous allegations as regards the conduct of Bonhams and its agents in relation to the commercial agreement, and particularly as regards the promotion and execution of the auction, and threatened to issue legal proceedings. All of the allegations are denied by Bonhams. So numerous allegations made that have been denied. E, Lohomij, as part of this deal, has agreed to extend the maturity. It had been extended once already, and they extended it another 7 months, and grant various other amendments to the facility. Well, one of them was the 13.6 million euros that was waived. And in connection with those amendments, the parties have, subject to the terms of this agreement, agreed to settle MRL's claims against the Bonhams parties and or Lohomij and or any of their affiliates and agents relating to, etc. And that language is the same as the language in the definition of claims. Now, can I make the rather obvious point that what is being given to MRL here, Lord Justice Phillips anticipated the points, is not nothing. It's 13.6 million in fees that are due under the facility. That's been waived. Time to repay has been extended by a further 7 months. They'd had, I think, 5 months already. And indeed, if one drills into it, a further 2 million euros has been advanced under the amended facility agreement. And in terms of the amendments to the commercial agreement, the main one is that previously, under the commercial agreement, Bonhams had been entitled to try and sell all the cars in the collection, but MRL, under these arrangements, was given the opportunity to sell the remaining cars if it wanted to, and if it succeeded in selling them on its own, Bonhams in that situation waived its entitlement, which it did have, to a 6% commission. So Bonhams is giving up its entitlement to earn significant sums on the sale of the remaining cars, and MRL is given the chance to avoid incurring those fees. So I said that the recitals refer to a lot of the factual context. The judge's consideration of the factual context started at paragraph 113 of the judgment. Page 246, so it's core, tab 11, page 246. And what he says at 113, paragraph 113, is the text of the settlement agreement has been interpreted in the context of the factual matrix comprising facts or circumstances which existed at the time the contract was made, which were known or reasonably available to all parties to the agreement. Well, completely orthodox. He started with the words on the page, but hasn't stopped there. He's turned to the factual context. And his conclusion is, as has been read to you already at paragraph 115, that nothing in the factual context indicates that the text of the agreement ought to bear any other meaning than the natural meaning. But he's done the exercise. And that's his conclusion, but he considers it in some detail through the subparagraphs of paragraph 115. He starts with the letter before action, and MRL seems to be saying that this is the only relevant factual context, but that is not correct. But it is obviously important context, and I want to just show you some passages from that, bearing in mind that I am aware that it's been read to you once already, or bits of it have, and I'm going to try not to repeat what you've already seen. So the letter before action, supplemental bundle, tab 14, please, page 125. And essentially what I want to, well, firstly accept and then point out is accept that in terms of the formal causes of action that are expressly alleged, they are in negligence and equivalent contractual claims. And I would also accept that the letter for action doesn't make any express claims against Lohomij. But it does contain numerous other allegations that are not strictly part of the negligence claims. And putting it bluntly, a reasonable recipient of this letter would have a read of this and think it was being accused of some pretty bad stuff. And of course, the letter isn't a pleading, and it can't be taken to be a pleading of conspiracy, and the word conspiracy is not mentioned, and nor, therefore, does it reach the standards that would be required of a pleading of conspiracy or others of the torts, nor indeed may it reach the standard of a legal plea of duress. But the point is that there's more than a hint here that if you're the recipient of this, you're facing negligence and its contractual equivalent now, but watch this space, because there's plenty of other bad stuff that we're accusing you of. And I mean, as against Bonhams, the negligence allegations are bad enough, but the other things that are either alleged or asserted or hinted at, they're among the most serious possible allegations of deliberate and dishonest wrongdoing that could be made against an auction house. Because what is being said is that Bonhams, or B&B, didn't achieve the best price at auction, in part because it made mistakes in the marketing process, and that would be one thing. But the allegations go back to May 2014, and the facility agreement, and the commercial agreement. And MRL is essentially saying it had been forced into those documents, particularly the commercial agreement. Now, the commercial agreement is obviously a three-way agreement involving Lohomij as well. And so if you've been forced into that agreement, if you're MRL, and you're Lohomij reading this letter, well, you'd be thinking, hang on, I'm part of this, I'm implicated in these allegations. Anyway, I'm not here for Lohomij. MRL was saying that Bonhams had deliberately put its own interests ahead of the client's interests. Not just messed up the auction, got it wrong, but deliberately, and for Bonhams' own benefit, arranged matters in a way that would get a worse result for MRL and a better one for Bonhams. And that is a very serious allegation. And as we will see shortly, allegations of deliberate wrongdoing, including serious breaches of fiduciary duty, are being made in this letter that go wider than negligence. And there are also more than allegations.
Can you point to the particular passages you have in mind?
My lord, I'm about to go to them.
Okay, sorry.
Could you give me 30 seconds?
Yes.
I was just going to say, you will also see as we go through the letter, statements as to the alleged close connection between Bonhams and Lohomij. And Bonhams is alleged to have used its connection with Lohomij to coerce MRL into the commercial agreement. So to answer the question, my lord, I'm not going to read the whole thing, but I will want to identify the passages that I'm particularly keen on. Page 126, then, if we're in hard copy, just below the second hole punch, second last paragraph, each of MRL, Bonhams and Lohomij, the funder of the transaction introduced by Bonhams to MRL, proceeded to work within the very short timetable, etc. The transaction was entered into in good faith on substantially the same basis as the offer, albeit with protest at the introduction by Lohomij of a larger premium on the loan. So already they're saying, well, Lohomij is mixed up in this as well, and we entered into the loan under protest. We weren't happy with that. Next paragraph refers in the third line at the end. It was agreed that a proposed tripartite agreement be entered into. That's a reference to the commercial agreement. It's obviously a three-way agreement that included Lohomij. I don't have anything else till page 128. But at the top of 128, it says the terms of the agreement, i.e. the commercial agreement, were finalised on 30 June. and then moving to the second paragraph, it said MRL reluctantly agreed to the final terms of the agreement wholly in reliance on Mr. Brooks and Bonham's expertise as both auctioneers. And Mr. Fenwick read that, but I would also encourage you to read the rest of the paragraph. Further, MRL understood the importance of the press launch and were not in any position to prevent the launch. Accordingly, they had no choice but to agree the terms of the revised agreement being proposed to them by Bonhams. And one could write in there, and Lohomij, because of course it was a tripartite agreement. And then underneath the italicized offset quotation, it said, it's very important to highlight that the terms of the draft agreement were negotiated and agreed between Lohomij, Bonhams and MRL throughout June, and indeed within the execution version of the agreement emailed by James Day solicitors acting on behalf of Lohomij and Bonhams. Now, that's wrong. James Day wasn't acting for Bonhams, but the allegation is clearly of a close connection of these two working together, Lohomij and Bonhams. Next paragraph, the revised wording inserted at clause 2.3 was only inserted on the afternoon of 30 June at Bonham's insistence. MRL's agreement was effectively only provided under duress in complete reliance on the professional advice of Bonhams. Now, Mr. Fenwick says, oh, well, word duress is there, but that can't be taken to be a pleading of duress. Well, it isn't a pleading of duress, but if you're the reasonable, solicitor receiving this letter for Bonhams, your alarm bells are going off about what might lie behind the allegations of negligence as well. Over the page, in the middle paragraph, in addition, Bonhams owed MRL a special duty of care as experts and specialist auctioneers of vintage cars and as MRL's agents. Well, that's an allegation of fiduciary duty if you're alleged to be someone's agent. The unique circumstances of the transaction whereby a significant shareholding in Bonhams is held by the same beneficial owners as Lohomij, MRL secured lender, means that MRL was beholden to Bonhams in a way they wouldn't have been with any other auctioneer. So they're saying that there's a connection, or that the connection that pre-exists between Lohomij and Bonhams means that MRL is somehow beholden to Bonhams. And I struggle a bit with what precisely is meant by beholden, but I interpret it to mean lacked freedom in some way vis-a-vis Bonhams, or owed Bonhams, or was somehow reliant on them. That the thrust of it is that it's being said that Bonhams could somehow force their will on MRL because of the connection that Bonhams had with Lohomij, which was the lender. Second last paragraph of this page, it's clear from the facts of this matter that it was not the sellers who was prepared to offer any car for sale without reserve, but Bonhams who forced MRL. Now, it may not be a formal legal pleading of duress, but coming back, forced MRL. Bonhams forced MRL. Any sensible solicitor receiving this letter is thinking, duress, forced. There may be allegations of duress and undue influence and the like coming. Over the page at 130, line 4, there's a reference to having done something that's unlawful in California. Second last paragraph on this page, last line of that paragraph, Bonhams withheld information from MRL.
I'm sorry, I've lost you. You were
I'm sorry, my lady.
First paragraph at the top of 130.
I
talking
was.
about California.
I was. I'm trying to balance
Yes.
going quickly with.
No, I'm
We're
very
getting-
grateful. Just if you take me back.
Same page, paragraph 130, second last paragraph.
Yes.
Beginning to further compound matters, line 4 of that, the last sentence,
Yes.
Bonhams withheld information. Well, that's, an auctioneer withholding information from the client is, seems to me to be an allegation of breach of fiduciary duty, albeit not called that. Over the page at 131, 1, 2, 3, 4 paragraphs down, it's MRL's contention that Bonhams was solely motivated by the publicity that would be generated for Bonhams itself in selling the cars without reserve and in the USA. So in other words, the accusation is that they don't have their client's interest first, as a fiduciary acting properly should, but they are solely motivated by their own interests in the publicity that they will get in selling in America, without reserve. Just above the second hole punch in the offset paragraph, beginning, this all reflects Bonham's previous advice to MRL, namely that the MRL collection, Maranello Rosso collection should be sold in the UK, either at Goodwood or at a special event in central London. Unfortunately, it is clear that Bonham's went against their own recommendation in selecting the USA, the simple rationale being it suited their own purposes and not those of its client. Now, this is a serious allegation of deliberate wrongdoing, or if it isn't, it could certainly reasonably be read that way by Bonham's and Bonham's solicitors receiving this. Then at the bottom of the next paragraph, it said, last sentence, it seems that Bonham's focus on its own sale process led to a conflict with it acting in the best interests of its client. Well, that is pretty close to a breach of fiduciary duty, or an allegation of breach of fiduciary duty, a conflict between its duty as auctioneer and the interests of its client is what's being talked about there. Then it said, there's no question that Bonham's owed MRL a special duty of care for the following reasons. That A refers to the nature of the connected relationship between Bonham's and Lohomij, MRL's secured lender. Over the page at D, it said MRL was coerced into agreeing sale of the cars without reserve in the USA. So we've had the word duress used, we've had forced used, we've had coerced used. And Mr. Fenwick tried to sort of soften this down. He said coerced is strong language. Well, it is strong language. What is being said here is that MRL is somehow being coerced or forced into entering into an agreement, and the means of that coercion is Bonham's is putting pressure on MRL, backed up by Bonham's close relationship to the lender. That's what's being said. The middle of this page, middle paragraph, second.
You say that that's then hinting at conspiracy.
Well, I'd put it a bit stronger than hinting, but at the very least it's hinting, and hinting would be enough for my purposes. It's expressly really talking about concerted action, which is pretty close to combination. It's saying that Bonham's and Lohomij are working together. They're connected in terms of their ultimate ownership, and Bonham's is using that connection to force, coerce, or to use duress MRL into the commercial agreement. So let me make it clear, the word conspiracy is not being used, but we're in the same ballpark. Middle paragraph here, Bonham's is being accused of having merely cherry-picked the cars that suited its own purposes best for promotion of itself in the USA. Well, I mean, there are so many serious allegations that one could lose sight of the fact that this is a really serious thing to say about an auctioneer, that you don't follow the client's interests, you choose the cars that you think will serve your own interests best. It's also said, for good measure, Bonham's has undervalued the remaining cars. So, my Lord, Lord Justice Phillips, those are the passages that I specifically rely on as saying that it's not just negligence or it's contractual analogue. MRL was saying, and I think in fairness it was doing more than hinting, it was saying, albeit not advancing them in pleading form, but the writer of this, I mean, letters before action are written deliberately. Every single word of them is thought about in terms of what its effect will be on the other side. There's no doubt that the writer of this letter is thinking, I'll hit them with the negligence, and they'll know that I've got other stuff backing it up, and if they don't settle, that they'll face this other stuff. That's what's going on commercially, and it would be a wholly negligent solicitor to read this and go, well, Bonhams, you're in the clear, really, apart from a little local difficulty about negligent conduct of the auction. I mean, that would just, you know, no reasonable solicitor would read this letter in that way.
Well, one might slightly turn that around on you, though, might you, and say that if it was stuck out like a sore thumb to solicitors, that there were potential claims in conspiracy, fraud, whatever, and given that the solicitors, Jones Day, in this case, must be taken to know about BCC and Ali and all the subsequent cases, would you not have expected, had they intended to cover those causes of action as well, that they would have been expressly spelled out in the settlement agreement?
Well, it's a correct observation that the words conspiracy and fraud, etc., are not used in the definition of claims. But the reason for that is the drafting style. It just doesn't purport to list all known causes of action. But conspiracy is a tort. Tort is mentioned, and all other claims are mentioned as well. But another answer to your question, my lord, is that the reasonable solicitor with knowledge of BCCI, on my reading of BCCI, knows he doesn't have to list every cause of action. And indeed, the reasonable solicitor...
He knows he may have to.
I'm sorry, my lord.
He knows he may have. Well, he certainly knows that in the if you don't put it in expressly, this very argument resulting in a hearing in the Court of Appeal might result. So you might certainly think that a solicitor who's received this letter would want to cover all bases for his client and expressly refer to those causes of action.
Well, I do agree with the first bit. The solicitor would want to cover all the bases.
You say he has.
The question is whether he has. Yeah. And of course, all points of construction that come to any court, and particularly this court, you know, you wouldn't be there if it had been drafted differently. And indeed, that's, you know, how claims work. The claimants draft around the settlement agreement. You know, that's why they choose the causes of action that they do. So that's not hugely surprising. But I think I do suggest that there is a point in, you know, the drafting mechanics. It doesn't purport to list all the causes of action. It works by subject matter. And of course, the more causes of action you list, you know, the more you might have left out. You end up with 4 pages of causes of action, and you'll probably remember Lord Hoffman's point about American drafting style in the BCCI case. He says that, you know, happily in England we trust to the, you know, the good sense of the court and express ourselves more sparely. But I mean, it's a fair point that you could put in 4 pages of boilerplate trying to list every cause of action under the sun, and then, you know, you wouldn't be having this argument. Really, say they'd have to get even more creative.
No, but you could put in many pages, but also you could just put in the very few words, including allegations of deliberate wrongdoing or fraud. You
could do that. You could. It's not the way this draftsperson set about scrubbing away the cause of action. I'll finish on the letter shortly. The allegations are clearly wider than negligence and its contractual equivalent. They include deliberate breach of fiduciary duty. They don't use those words, but that's what the allegations amount to. They include an allegation of conflict of interest. They use the words duress and coercion. They clearly are describing commercially unacceptable, dishonest behaviour, and it's clear that Lohomij is also implicated. Lohomij is implicated because of the connection, or the supposed connection, between Bonhams and Lohomij, and it's that connection, or supposed connection, that is said to give Bonhams the power to coerce MRL into the commercial agreement. And indeed, Lohomij was the party to the facility agreement that in the letter of action, MRL says it entered into under protest. And if we compare the allegations in the letter for action to the particulars of claim at core 16, page 368. Paragraph 1 is the executive summary. This, one could fairly assume, is a carefully crafted encapsulation of what their claim is about. And what you will see if you read it is that the allegations against Bonhams in these proceedings are very similar to those in the letter before action. So in the first sentence, this is a claim for, amongst other things, unlawful means conspiracy and deliberate breaches of fiduciary duty. Well, we've seen deliberate breaches of fiduciary duty in the letter before action. It said in the middle of this paragraph that the defendants acted dishonestly and conspired to force a sale of a selection of the cars contained within the collection. Well, we've seen allegations of commercially unacceptable and dishonest behaviour and of forcing a sale. And it said in the last 4 or 5 lines, they did so solely to advance the reputation and international profile of Bonhams in advance of a proposed sale of business to a private equity investor. They dishonestly put their own financial interests above those of their client in breach of the fiduciary duties owed by Bonhams, B&B, and their servants and agents. So, I mean, what I'm drawing attention to is that the allegations, in summary, in the particulars of the claim are really very similar to the allegations in the particulars of claim. And if you read into the body of the particulars of claim, which is 52 pages long, and I'm not going to read it, but you can see that in terms of the factual subject matter and the facts being complained of, the allegations against Bonhams are pretty similar to what's in the letter before action. And it's hard to believe, I suggest, that what I've said is the comprehensive drafting style of the settlement agreement was intended to catch the letter before action claims, which it clearly was because it refers in terms of the letter before action, but not the particulars of claims, because they both arise out of the same factual subject matter, and they're so similar in terms of the thrust of their complaints. And there's nothing in the drafting of the settlement agreement to encourage you to think that the settlement is intended to settle one lot of claims arising out of acquisition, financing, sale, and the commercial agreement, but leave another lot arising out of the very same facts up for grabs. There is no attempt to carve out specific claims that MRL might have. It's not expressed in terms of settling some causes of action, not others. That's not the drafting technique. And importantly, and I did read this, but the settlement agreement also settled all unknown claims. It used the phrase whether or not known. So the release settles all claims arising from the subject matter, however they may be formulated or packaged in legal terms, whether or not known. And just in terms of, you know, what's commercial, there's no commercial reason why the parties would agree to settle negligence claims only when much more serious allegations are being made at the same time, because this settlement wouldn't, as it were, solve the problems in the relationship. And this was meant to be a continuing relationship. And I suggest it is an unlikely intention to leave allegations of deliberate wrongdoing and breach of fiduciary duty sort of out there hanging over the relationship, particularly when the relationship was going to continue and require cooperation. From Bonham's perspective, the only real addition to the particulars of claim from the letter before action is a prior agreement to do the things that are being complained of. And my point is that it cannot be right and isn't right that the settlement is intended to settle all claims arising from allegations of Bonham's wrongdoing in relation to the stated subject matter. But if it was planned before the so-called exclusivity agreement then all bets are off, and actually those claims haven't been settled. That is just not a commercially likely agreement to enter into or intention. I've mentioned a few times probably that coercion into the commercial agreement was an allegation that Bonhams threatened that Lohomij would foreclose on the loan. That is an allegation of concerted action. And Bonhams and Lohomij being connected and working together to do down MRL, if I can put it that way. And it's worth just making the point that the commercial agreement, the tripartite commercial agreement, required certain decisions in relation to the sale of the collection to be made jointly by Lohomij and Bonhams. So the much more likely objective intention, I say, from the words of the release and the definition of claims, is that the parties intended to settle all claims, however formulated, whether or not known, arising from the acquisition, financing, sale, etc. The letter before action is not the only relevant factual context. There's also the without prejudice letter at the next tab, tab 15. And all I would point out on this is that the settlement offers, if we go to 135 under settlement offer B, assume that Bonhams is in a position to procure that Lohomij will release security, waive interest on the facility agreement, i.e. the offer itself assumes that Bonhams and Lohomij are working in concert together and that Bonhams can direct Lohomij, in essence. So this is also part of the factual background to the settlement agreement. There are probably two other relevant aspects that judge your attention that I would also mention. There's an alleged meeting, a meeting at the end of June, and we can see this in the pleading, particulars of the claim. So it's core tab 15, page 378. So, page 378, paragraph 38 at the bottom of the page, it said, at this meeting, i.e. on the 30th of June, Mr. Brooks and Mr. McLean, who was acting on behalf of both Bonhams and Lohomij, well, they must have been connected and working together if one person was acting for both of them, also informed Mr. Sullivan that if MRL did not agree to the auction in California, then Lohomij would simply wait for it to default on the facility agreement, at which point the collection would be repossessed. Mr. Sullivan, in his witness statement, paragraph 61, speaks of having been ambushed. I won't turn it up, but it's supplemental bundle, page 196. Still in the particulars of claim, but moving forward to page 396, please. This is in the particulars of combination under the heading unlawful means conspiracy. Paragraph 119 over the page at 2, Mr. Luhmann was the controlling mind of Lohomij and part owner of Bonhams and therefore able to exercise control over both companies. So it said he's in a position to make them work together, and we've seen that they're alleged to have been doing that. And then in 3, Bonhams consistently threatened MRL that Lohomij would enforce the onerous terms of the facility agreement, debenture and guarantee, if MRL did not agree to Bonhams' terms. Such threats could not have been made unless Bonhams and Lohomij acted in combination. Well, this allegation of acting in combination is made on the strength of facts that were known at the time of the settlement agreement. And for good measure, at sub 4 here, despite the fact that MRL's letter before action pursued a claim against Bonhams only, Lohomij insisted on being party to the settlement agreement, there was no reason for Lohomij to be protected by the settlement agreement unless it was party to the wrongdoing perpetrated by Bonhams. And B, there'd be no reason for Lohomij to accept a substantial reduction had it not acted in combination with Bonhams. Well, these facts that are being relied on to plead the combination are facts that MRL knew about and was complaining about before the settlement agreement. Yeah, I'm being told alleged facts. They're alleged facts, but for this purpose, I'm stuck with alleged facts. Right, and there's also reference, turn back, please, to the previous page 396. Part of the conspiracy at 117 sub 3 are threats by Mr. Brooks on multiple occasions to destroy Mr. Sullivan and therefore MRL. So that's between the date of the letter before action but before the settlement. And this has been expressed in more colourful language by Mr. Sullivan in his witness statement, and the reference there is tab, supplemental bundle, tab 25, page 204, but he also uses the word destroy. So what I would say, having gone through the factual context, is that it actually doesn't really do a lot more than confirm the clear, natural meaning of clause 3.1, i.e. the release and the definition of claims, and these parties objectively intended to settle all allegations, including of deliberate wrongdoing, combining with intent to harm MRL to the benefit of Bonhams and Lohomij, and they did it. My lord, that's what I've, my lady, that's what I've got to say about ground 1, Roman 1. I'll turn now to ground 1, Roman 2, which is sharp practice, please. And they say that MRL, say that the so-called sharp practice principle should be applied to prevent the respondents from relying on the release. There's nothing in this at all. MRL does not say that the judge got the principle wrong in the sense of misstating what the law is. He didn't. They don't say he did. He quoted the relevant passages from the authorities. You see that at paragraph 91 sub 6 and paragraph 108 of the judgment. And I mean, the facts were that before the settlement, MRL alleged all the things that we've gone through, a course of concerted, deliberate wrongdoing, essentially that Bonhams and Lohomij ganged up on MRL, and that MRL was thereby forced into the facility agreement and the commercial agreement and a supposedly disastrous auction, all with deliberate intent to benefit themselves and harm MRL. And that was all out there pre-settlement. And in the settlement agreement, MRL expressly gave up unknown claims, whether or not known, that related to a particular subject matter. So to the extent that that the settlement didn't expressly mention a cause of action, well, that's explained by the drafting style. It also doesn't matter because it gives up claims whether or not known, so long as they relate to the subject matter. And these claims obviously do. The particulars of claims are on any view very similar and arise from identical subject matter. Now, MRL had legal advice. They took their time and they decided to accept 13.6 million euros plus a 7-month loan term extension plus 2 million more euros of lending plus various other favourable changes to the agreements in exchange for releasing known and unknown claims. And on any view of the scope of the sharp practice principle, that's not sharp practice and there's no reason for equity to intervene. MRL say that the judge should have waited for the facts to be found at trial, but that's wrong. it's perfectly okay and indeed orthodox to decide the facts on, to decide the point on MRL's version of the facts, which he did. It's orthodox. And MRL say that this is a developing area of the law and there should be a trial. Well, I'm not sure really it's that hot a topic in the law, but it would be a developing area, if it is, whether you decide the point now or later. The reality is that on any view of the scope of sharp practice, there hasn't been sharp practice here, and it's not going to help MRL on these facts. The judge addressed the principle in the judgment at paragraph 119, core 11 to 50. Mr. Fenwick read practically all of it to you. I will not read it. I have nothing useful to add to paragraph 119 on sharp practice. The judge was right, and the reasons he gave were also right. So that's all I have to say about ground 1, Roman 2. Just before turning to ground 2, I should just be clear about something, and while we're in the judgment, just before Mr. Fenwick turned to ground 2, he went to paragraph 121 of the judgment, and if I understood him correctly, and what he said will appear from the transcript when we get it, but I understood him to be criticising the judge for saying that the conspiracy was settled even if there'd been post-settlement acts. All I want to do is point out that that is not a point that's available to him, because it's not in the grounds of appeal. It just isn't there. You won't see it there. If you want to have a think about the point anyway, the judge was right for the reasons he gave at paragraph 121, but the prior point is it's not available on this appeal. That takes me to ground 2. Fiduciary duty and duty of good faith. Ground 2 obviously only arises if MRL succeeds on ground 1. If I would say that if the claim for conspiracy has been settled, the claim for breach of fiduciary duty and breach of contractual duty of good faith must also have been settled, because it's the same wide language and it's the same facts. The factual complaint that comprises the breach of fiduciary duty or the breach of supposed breach of good faith is of having forced into the commercial agreement. And that's very obviously been settled because it was expressly mentioned in the letter for action. So I hope I can take this more shortly, although whether I get done by 4:15, I'm not sure. Fiduciary duty, MRL claims that the exclusivity agreement, or the so-called exclusivity agreement, because we don't accept it is one, gave rise to fiduciary duty. Can we see where that is pleaded, please? Particulars of claim, core 16, 376. My Lord Justice Phillips found at page 399 at 121 sub 1 some pleading in relation to breach of fiduciary duty. I'm just pointing out at page 376 there is well, such pleading as there is here at paragraph 28. It said, by insisting on an exclusivity, Bonham specifically required MRL to stop negotiations with RM, so MRL was in practice committed to contract with Bonhams or lose the deposit. In the circumstances, Bonhams owed MRL a fiduciary duty to act in the best interest of MRL as their agents for the transaction and or to obtain the best price for the collection. Further, alternatively, Bonhams owed MRL a duty of good faith, and that is the full extent of the pleading of the duty of good faith and fiduciary duty. I would just comment on in relation to how this is put in line 5. Bonhams owed MRL a fiduciary duty to act in the best interest of MRL as their agent. Well, you're not an agent until you've agreed to be an agent. And if you're negotiating about whether you'll be an agent and the terms in which you might be, you're not an agent. As soon as you've agreed to be an agent, then you're an agent, and then you owe fiduciary duties, but not before.
There's also the rather ambiguous phrase, for the transaction. It's not clear whether it means the transaction there means the transaction for which they're agreeing exclusivity, or if it means the overall transaction of selling the collection.
Well, I haven't had a chance to think about whether this helps me, but I tend to read it the other way, the latter way, the second way. But we'll see.
Well, I think that must be what it means, but I'm not sure it makes a lot of sense. The exclusivity which is said to have been demanded was to stop negotiations. But that in itself doesn't make Bonhams MRL's agents. And it's said simply by agreeing that exclusivity, MRL was owed a fiduciary duty by Bonhams as their agents for the transaction. It seems to me I just don't understand how one follows from the other.
Well, I don't want to seem overly opportunistic, but I don't particularly understand it myself.
Well, that was a point. It's a point which we explored with Mr. Fenwick. So it's not a new point.
Yeah.
But for example, it's commonplace up and down the country that somebody wanting to buy a property will say to the vendor, "I'm going to buy your property. Please agree with me that you will stop negotiating with other persons, take it off the market for a period while we conclude the deal, exchange contracts." And no one could possibly allege that agreeing that exclusivity gave rise to an obligation gave rise to a fiduciary duty or duty of good faith. Quite the opposite. We know it doesn't.
I'm trying not to be opportunistic, but I do agree. I mean, what I would say about the pleading of the fiduciary duty is that it is based on the, and this is Lord Justice Phillips' point, that it is just based on the 22 May 2014 email exchange. And Mr. Fenwick, on his feet, started to sort of rely on subsequent acts of sort of moving cars around the world and getting them ready for auction. But that's not the case we're meeting and that's available to him. If we could go to that 22 May letter, it's supplemental bundle tab 4.
Mr. Gledhill, just before we get on to the details of the letter, can I ask you a general question in this area, which is what your response is to Mr. Fenwick's reliance upon the example of a solicitor? Because what he pointed out is that it's well established that a solicitor may act as agent for their client and indeed owe a fiduciary duty in advance of the retainer actually being signed. And I assume you wouldn't dispute that that's accurate as a statement of the law. The question is, why?
I think the answer, my lord, is when, as soon as the solicitor does something for the client, even if a retainer letter hasn't been signed, he has agreed to act for the client, at least to that extent. He's taken on the responsibility just by doing the action. He's agreed to act. So as soon as the solicitor does something on behalf of a client, not signing a retainer may raise all sorts of regulatory issues or issues of that kind, but there's been an acceptance of the role of fiduciary. They're not, at least in relation to that act, they're not negotiating anymore.
Just to be clear, so take the most common situation, which occurs daily up and down the land, dozens of times, which is where the solicitor issues a claim form on behalf of the client, even though the retainer hasn't yet been signed, e.g. because it's come through the RTA protocol or for whatever other reason. There's a limitation issue. There can be loads of reasons why claim forms have to be issued speedily, and it's pretty common, actually, for solicitors to do that for their clients, even though the retainer has not yet been signed. And as I understand it, your submission is, well, yes, but by issuing the claim form, they are implicitly agreeing to act in a fiduciary capacity.
Yes, they may not have agreed to act going forward. There may be aspects of the relationship that are not agreed, but in relation to the issue of the claim form, they've accepted the obligation to do that, they've agreed to do that, and in relation to that at least, they'd owe a fiduciary duty, even if they haven't formally signed a retainer letter.
Okay, well that's a helpful point as well. So in other words, to be clear, what you're submitting is, even in that kind of scenario, the extent of the fiduciary duty owed may be quite limited.
Well, it will always come back to what the alleged fiduciary has agreed to do, because you can't be a fiduciary without agreeing to take on certain obligations that require you to act in someone else's interests. To the extent that you've agreed to take on such obligations, you may well be a fiduciary in relation to those.
Thank you.
My lady, my lords, could we go to supplemental bundle tab 4, page 9, please? And what I was saying is that the fiduciary duty, its existence, is based purely on this email and the response to it. Much, but not all of it, has been read to you, but it's important, and I just want to draw attention to a couple of passages in it. Second paragraph, I confirm that, 1, a member of the Lumen Group will make funds available subject to contract to your client, MRL, to assist in acquiring the entire issued share capital. Bonhams will sell 70 Ferraris, etc., owned by Stella Bar by public auction at the Goodwood Revival, or on at such other dates and venues as may be agreed between MRL, Bonhams, and LG. I just pause there. Even this is imagining that there may well be sales other than at Goodwood, on or at such other dates and venues, but that's not the point that I'm on. Then you have, next paragraph, the above is subject to your confirmation that there has been an offer, and this is relied on as giving rise to an exclusivity obligation or a lockout obligation. And then the next paragraph, so 1, 2, 3, fourth paragraph says, we will do our best to meet the timetable discussed with you with a view to making funds available and completing the transaction on 29th May. This is subject to receiving from you soonest copies of all material documents and information, and to your full cooperation in assisting us fully to investigate and understand this transaction with the benefit of the advice and professional opinions which your clients have received. As discussed with you today, the most efficient and quickest way for us fully to understand the transaction will be for you and me to meet, etc., and to work full-time without interruption for as long as necessary to understand all the relevant issues and documents. Next paragraph, if you wish, LG will arrange for confirmation to you from their bank that the funds are available, subject to the conclusion of satisfactory investigations and subject to contract. In view of my confirmation to you, I hope this won't be necessary. then over the page, will you please send me by return the confirmations requested in the second paragraph above, followed by copies of all material documents and information. So very obviously here, Bonhams is saying, we'll do our best to meet your timetable. It's subject to getting a lot of documents. We need to do our due diligence. We need to investigate and understand. We need fully to understand all relevant issues and documents. And subject to contract, said twice. So in fairness to Mr. Fenwick, he's not seriously saying that this is a binding legal agreement as regards obligations to sell cars. As I understand him, he's really only saying that the binding bit may be an exclusivity or lockout obligation. But as regards the obligations to do anything in relation to the collection, i.e. to get cars ready for sale and to sell them, clearly any such obligations are subject to contract and subject to further obligation. And so there's no contract in relation to Bonhams acting in relation to the collection. That hasn't happened yet. And there was no such obligation in relation to the collection until the commercial agreement was signed on the 30th of June. And so no doubt people on each side's working assumption or hope or expectation was that an agreement would be entered into. But until there was an agreement, there wasn't an agreement. And there was no agreement as to whether Bonhams would act or as to the terms until the 30th of June. And until then, it was a matter for negotiation between MRL and Bonhams and Lohomij as commercial counterparties. And before lunch today, Mr. Fenwick said that MRL, had an expectation. I think he used the word was expecting. And that's all very well. No doubt both sides had expectations. But there's expectations and then there's agreements. And the whole point of using words like subject to contract and we've got to do further investigations is you are essentially saying we're not bound until we're bound. And until you've assumed the obligation to act as a fiduciary, you're not a fiduciary. And what was happening here is Bonhams and MRL were negotiating as to the terms on which Bonhams would act and whether Bonhams would act. The judge found that this email did not create a contract binding on Bonhams to buy the collection and sell it on, and that was the pleaded exclusivity agreement. He's clearly right about that. He discussed this in the judgment, which is core tab 11, page 253. My lady, I'm just wondering whether you're going to insist on 4:15 as per the
How long are you
timetable.
going
So I'm
to
not
be?
going to finish the point before 4:15.
How much longer do you need for the point?
Well, I think it would be better to hit good faith as well and start again tomorrow. I'm well ahead of schedule, if that helps.
I think that's absolutely fine, and I think it's appropriate that you should pick up tomorrow and deal with the end of this, with good faith as one. You've also already had 10 minutes more because we started, we were 10 minutes. So if you're ahead, you're not as ahead as far as you thought you were.
I'm still ahead, my lady. I'll take
I must admit, I felt sure you were, but I thought I would also warn you that you had 10 minutes more because we started at 3 instead of 3:10, because we had our 10-minute break up to 3 o'clock. As it seems to me that on behalf of the respondents, the time is generous, 10 minutes have gone and have been had. So there we go. I'm sure you won't complain about that. So we will begin again at 10:30 in the morning. Thank you very much. All right.